One with the roads out there. Since we were starting in a subcommittee, I'm going to go ahead and call Senator Henderson to the stand to present his Senate Bill 258.
288.
Oh, there's a staple. There's a staple right through it. So that was a guess, and I was wrong. So it's Senate Bill 288. Senator, proceed when you were ready.
Thank you, Mr. Chairman and committee person, since we have two in here. But thank you very much for hearing it. For the record, Senator Mike Henderson from the 3rd Senatorial District. And I will have a sub on here. You know, originally it said Associate Circuit Judge. I've been working with the judges back in my county, and we even looked at it. I think they do a workload study, and we are actually in line to have another circuit judge by the workload study. I'll give you a few examples of it. The 24th Judicial Circuit comprises of St. Francis, St. Genevieve, Washington, and Madison counties with a total population of 122,000. Currently, there are 2 circuit judges, and I'm speaking of that because there will be a sub on that. The judges hear felony, criminal cases, civil, and juvenile. What is unique about the 24th is that we have 3 prisons, and 2 of them being the largest prisons in the state. This makes a total inmate population around 6,000. And because of the prisons, the Judicial Circuit has a substantial amount of litigation, including the violent crimes committed while in the facilities. The 25th Judicial Circuit has 133,000 people, which is 11,000 larger than 24th, yet the 24th has more felony and criminal filings. I have many more statistics, but I do know that we're actually in line by the caseload study. I think you're probably familiar with that. They do. And with that, I'd be happy to answer any questions.
Senator, do you know if there's any backlogs right now on any of the dockets? Have you heard from any of the
judges? There
judges?
is. I've got that information right here. Let me see. Let me look at this. Okay. One moment, sir. I'm looking for it here, but I've got the backlog somewhere here in my information.
And if you can't find it right now, we can talk offline. And
okay, I've got it, and I'll get you this information that there is a backlog there. And I left out one important thing too. We have the sorts unit, and it has most of the sorts people for the state, and that entails a little bit more work too, if you're familiar with that. So I will get you that, Mr. Chairman. I will get you that information.
I appreciate that, Senator. Any questions for the Senator on Senate Bill 288? Senator Mack.
I just had this one question. Good morning. How are you?
Excuse me?
I said good morning.
Good morning.
Listen, when it's the bottom part, the Associate Circuit Judge shall not be included in the statutory formula for authorizing additional Associate Circuit Judges per county. I haven't read that section 478. What does that mean?
What we're doing in here, we actually were asking for that originally. I'm going to have a sub that's asking for a circuit judge. I just got done talking. He may testify here in a minute that I think they do a caseload study, and I think we're actually in line for a circuit judge, and so I'm going to have to get some of that in the budget and financing too. But yeah, what I'm doing is trying to follow our judges. They first said we can get by with a circuit judge. After they looked at it further, they said we need, associate circuit judge. We need a circuit judge. Okay. And I think we're in line with that from the statutes too, with our workload.
Okay, thank you. Very good.
Any further questions? Seeing none. First witness in support of Senate Bill 288, please come forward. Any witnesses in support of Senate Bill 288? Seeing none. Any witnesses against Senate Bill 288? Seeing none. Any for informational purposes? Seeing none. Senator, do you have any closing remarks?
No, thank you very much for giving me the opportunity to present this.
Absolutely. That will conclude the public hearing on Senate Bill 288. We're going to continue waiting for at least 1 or 2 more members before we jump into a quick executive session. So with that, we're going to move to Senate Bill 196. I believe there are some witnesses here and the sponsors here. Senator Moon, please proceed when ready on the public hearing on Senate Bill 196.
Good morning, Mr. Chairman and committee members. My name is Mike Moon. I represent the 29th Senatorial District, here to present Senate Bill 196. And in Missouri, crime prevention is a priority, as it should be. The worst crimes deserve the harshest punishments. I think we would all agree with that. And sex crimes against children have long-lasting results. I was looking at a study recently that showed that PTSD is one of the results, as well as schizophrenia, and those are lifelong symptoms. We must do all we can to protect children from these horrific acts. And Tennessee, Alabama, and Florida have enacted laws similar to the one that I'm presenting today. You might remember the Supreme Court has decided that this is unconstitutional. And what I'm hoping is that if Missouri will get on board with these other 3 states, that we can cause the Supreme Court to take another look at it and reconsider those options. The bill itself primarily has provisions that if an act of statutory rape or sexual trafficking on a minor is done and charges are brought against and conviction, that the death penalty would be allowed in these cases. And that's essentially it. If you have questions, I'd be glad to answer those.
Any questions for Senator Moon? Seeing none, before we jump into witnesses, can I get a show of hands on who is here in support of Senate Bill 196? Can I get a show of hands who is here to testify against Senate Bill 196? Okay. Last call for witnesses in support of Senate Bill 196. Seeing none, we're going to move to those against Senate Bill 196. Please come forward. And Sharon, I know it's rough on your voice, so if you have any written testimony, feel free to give that, and we'll spread that out through the committee. Proceed when ready.
Thank you, Mr. Chair. Sharon Galway-Jones here today on behalf of Missourians to abolish the death penalty. We are against the death penalty in all cases. We believe that life imprisonment without possibility of parole is sufficient punishment even for the most heinous of crimes. And so for those reasons, we oppose the bill.
Questions for the witness? Seeing none. Thank you for your time, and thank you for getting through that testimony. Next, against the Senate Bill 196, please come forward. Any further witnesses against Senate Bill 196? Seeing none. Any for informational purposes? Seeing none. Senator, any closing remarks? No, thank you. That will conclude the public hearing on Senate Bill 196. Now moving to, are we fine going to another? Okay. Now moving to Senate Bill 295. Senator Brattin. Proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Rick Brattin, 31st Senatorial District, Cass, Bates, and Johnson counties. I have before you Senate Bill 295. What this bill would do, it would ban the adult cabaret performances in front of minors. And, you know, it's definitely geared towards protecting children from these displays of sexual content. In the opening definition in the bill, it is geared towards the prurient interest, which by definition is sexual in nature and those sorts of things, and it creates a penalty provision of a Class A misdemeanor for the first offense, and then anything following would be a Class C felony for those sorts of performances done in the presence of minors. It's happened a couple times actually in my district. I know in Rolla they had a case where this was occurring, and even having kids putting dollar bills in bras, and these sorts of things I think are just egregious in nature. And the fact that we're actually having to do a bill to prohibit this should be common sense, and it's unfortunate that there are even parents that would even take their kids to these sorts of performances, but it happens, and we need to make sure that we're protecting the innocence of youth, and that's what this bill seeks to do and to remedy. So be happy to answer any questions.
Briefly on, before I turn to Senator May, on the definitions of adult cabaret performance, I just have to ask, what is a go-go dancer?
I don't know. I would assume it would be somebody, if they're I don't know. I guess I'd have to Google that.
Well, yeah, we'll work on that. And I know it's been in several bills through the years.
Yep.
Now I just have an opportunity before a committee that I'm on. I can ask, what is a go-go dancer? So we can work together to figure out what that is.
I don't know if that was like an old, kind of an archaic term for like a stripper or something like that, or exotic dancer. I don't know. But I think they're just trying to encompass all usages of the terminology, I would assume.
Senator May.
Yeah, so you're saying these performances are happening outside?
I couldn't hear the question, excuse me.
I said you're saying these performances are happening outside?
Well, they're happening everywhere. They're happening, I know in my district it happened in an Elks Lodge, and they've done it for the past couple of years.
Yeah, but normally they're happening in places where, you know, you should be 21 and over. And sometimes restaurants may have singers come to those restaurants, but they're normally family-oriented restaurants. And so I'm concerned that it may be too broad.
Well, I mean, it definitely in the definition says in the prurient interest and those sorts of entertainers with, so it's geared towards sexually explicit type of performance where you're strip teasing and taking off clothes and acting in a sexual nature, like touching yourself.
Oh my God.
I can send you some links of those types of performances if you'd like to see what I'm talking about.
No, thank you.
So yeah.
I'm good. I'm just concerned that, you know, so as long as these are happening indoors in an adult setting.
Oh yeah, it
still
doesn't ban
impact
above
that.
adult. So adults can they can do whatever they wish. This is for minors only. Is where this penalty provision
Thank you.
would kick in.
Any further questions? Seeing none. Show of hands, who is here to support Senate Bill 295? Show of hands, who is here in opposition of 295? All right, so we will start with last call. Anyone for Senate Bill 295, please come forward. Seeing none. First witness in opposition. You're going to have 5 minutes on the testimony because we have a couple other bills in executive session, so please come forward and proceed when ready. Make sure you have a witness form filled out that you can leave on the witness stand.
All right. Good morning, Chair and committee members. My name is Chris Lehman. I'm a resident of Boone County, and I'm testifying in opposition to SB 295. I am a co-owner and operator of Inclusion Plus. We partner with restaurants, event spaces, public city buildings, bowling alleys, dog park bars, and more to produce drag shows across the entire state of Missouri. We operate from Jackson to Johnson counties, Adair to Camden, Boone to Randolph, and Franklin to St. Louis. Since May of 2020, we've produced 81 all-ages drag or trivia shows, resulting in entertaining over 3,347 Missourians who pre-purchased tickets. We've seen families dance in their seats, sing along to Frozen or Moana, and provide LGBTQ plus families, allies, and their coworkers and friends weekend entertainment. SB 295 plans to outlaw drag shows that can be viewed by minors or if they're located on public property, all while appealing to prurient interests. This bill would violate the First Amendment and the Equal Protection Clause of the 14th Amendment, specifically as pride festivals fall under peaceful assemblies. The direct harm will be felt as the entertainment aspect of LGBTQ plus centered events such as pride fests and drag story hours will be eliminated. One example I have is that since 2019, during COVID, Midmo Pride Fest has tripled in patronage from less than 3,000 attendees to around 8,000 in 2024 and 9,000 in 2023. 25% of booth rentals were businesses located outside of Boone or Cooper counties, This generated around $12,000 that Pride Fest paid the City of Columbia in administrative, city utility, first responder, and licensure fees. The aforesaid statistics tell you that Missouri small businesses are crucial to family-friendly drag shows, both in logistics and operation settings. This bill will harm Missouri small businesses, sales taxes, lodging taxes, the hospitality industry, the gig economy, and families who simply want to express their parental rights of decision-making as a family unit. Unwanted legislation interferes with parental and guardian rights of decision-making for their own families. The ramifications of SB 295 can be expanded to minors performing in school-sanctioned theater, such as if a girl plays Peter Pan, or if a boy plays Wendy. Anyone dressing in androgynous clothing or presentation, no matter their age, can fall under the providing entertainment verbiage on page 1. This is the third year that I've testified in opposition to similar drag ban bills. The internal contradiction, broad definitions, and simple fact that the term prurient interest has 4 different university-published definitions makes this once again a bad bill. The art of drag already has a rating system tied to age appropriateness. It's called age designation. Shows can be rated 21 plus, such as at a bar, if their business license says 21 plus, 18 plus if vulgar song lyrics are played, or family friendly, where the performers are literally singing Disney and show tunes and princess dresses. This bill inappropriately assumes that all drag performances are hypersexualized. That is far from the truth and is blatantly hateful and discriminatory. The Class A misdemeanor mentioned on page 9 has harsher punishments than DUI charges and businesses who violate child labor laws. Since we're talking about protecting children, an additional magnifying glass really should be placed there. Rather than tying illegality and criminal punishments onto art, I ask you to let performers and businesses utilize common sense safeguards we've established as artists, managers, and fellow Missourians. In summary, this bill is unjust and unneeded. Senator Brattin, I'd like to reach across the aisle and attempt something that I've never seen offered at a hearing before. On March 30th in Ashland, Missouri, I'm hosting an all-ages drag show at the Dandelion Cafe. I'd love to give you and your family complimentary tickets and let you see firsthand that all-ages drag doesn't appeal to prurient interests. Thank you for your time.
Thank you for your testimony. We're going to save applause. There will be no applause or outbursts, or we will have the Sergeant at Arms escort individuals out of here. Thank you for your testimony today. I'm looking at the definitions that we use in Missouri law, and prurient interest is readily in a lot of our criminal statutes. Primary appeal is to prurient interest in sex, 573010. That's 573040, 573050. So is there a different term that you would recommend that this committee use in modifying this to reach the intent of the legislation where minors aren't exposed to sexual material? I think when you look at the legislative intent behind many of the laws that we've had in criminal law dealing with children, exposure to some of these other adult cabaret performances, we have age limits on who can go in there and penalties on that. So is there another term that you would prefer using in this language here?
Yeah, so I found Merriam-Webster had prurient interest as immoderate or unwholesome, and then the 3 others just had different shameful interests regarding sexual interests. But I think the bigger question here is that there are already safeguards and terms around drag as sexual nature only being visible and viewable to adults. That's why we literally check IDs at the door. I'm on our security team. That's part of my job, is checking IDs if we're doing a show at a bar to make sure that the people there are above 21 or above 18 plus, however the venue is in agreement with. And so we're still missing the point of, like, there's already safeguards here in place for all ages drag. It's the content is thoroughly combed through. There's no swearing in the languages. We're taking pop songs by Taylor Swift and we're already eliminating further vulgar language. So there's a part of the bigger argument here.
Now, looking at the definitions on adult cabaret performance, I don't know if you have the bill in front of you. It's a performance in a location other than, and it gives several different categories, other than an adult cabaret. So we're not including the locations that you were mentioning, that you're checking IDs, only adults are allowed in there, that feature topless dancers. So do you believe that minors should have access to, if parents want to take them into, a topless strip club?
No, of course not.
So are you fine with that provision in there of not allowing minors to have access to shows with topless dancers outside of adult 18-plus nightclubs?
Correct.
And any idea how to define go-go dancer, what that is? I looked up a little bit. I know it's mentioned in our laws, but any idea?
I'm not an expert. I don't know.
Okay. And exotic dancers, strippers, we're just going to kind of group those together, as I think they are defined in our laws as well. Do you think that minors should be able to be in a performance with exotic dancers or strippers?
No. However, the rest of the bill language goes on to, it bundles everything together. So we're sitting here talking about male and female impersonators who provide entertainment.
That appeals to a prurient interest. And that prurient interest.
But we've already said that prurient interest has so many definitions that it.
But in Missouri law, it's very tightly defined. When we look at materials appeal to sexual interest in 573010, and we can tighten up these definitions. So that's why I'm trying to work to meet the threshold that both individuals sitting at the witness stand here, I think, want to, continue allowing for free speech, but at the same time protecting the minors that may be exposed to some of this stuff that is adult material. So if you have any other definition, alternative definition, or any clarifier, would be more than happy to work with you and address that in here. Let me turn it over to the committee. Any questions for the witness? Seeing none, make sure you leave your witness form there, and the next witness in opposition, please come forward. You will have 5 minutes. And for the committee, after this witness, we're going to go we're going to take roll and then go into executive session for those that have other committees to go into. Thank you very much. Begin when ready.
Thank you. My name is Sage Quorum. I'm here on behalf of the American Civil Liberties Union of Missouri in opposition to Senate Bill 295. The First Amendment protects from government limits on our freedom of speech, and this bill threatens our right to both creative expression and gender expression. Drag is a form of creative expression like any other, and the bill's broad prohibition of adult cabaret performance on public property in a location that, quote, could be reasonably expected to be viewed by a person who is not an adult covers conduct almost anywhere in the state. The impact of this restriction of expression and broad prohibition on location would result in a chilling of free speech in a variety of arts performances across Missouri. These bans threaten businesses, libraries, performers, and the people they serve by putting the power to decide what's appropriate in the hand of the legislators. The freedom of speech means that the government cannot discriminate against or silence voices based on the content and viewpoint of their speech. That is exactly what this bill proposes to do, and so we are opposed to this bill.
Thank you for your testimony. A couple questions real quick. On the violation of the First Amendment, do you all have any case law that similar cases or similar laws have been struck down on violation of the First Amendment?
Yeah, absolutely. So drag bans have been put in place across the country, and they've been met with legal challenges across the country in response to those bans. I'd be happy to provide information on each of those cases to the committee in full afterwards, but one case site that I do have right here, Shad versus the Borough of Mount Ephron, which was a case in 1981.
So it's 1981, that was before I was even born. Do we have anything in the last 20, 30 years? I know you've indicated there have been bans on drag shows very recently. So do we have anything in the last 10, 20 years?
We definitely do. that case that I just cited, that said that drag is a form of creative expression, and dance, fashion, and music are all protected by the First Amendment. That's that case cite. In regards to the current lawsuits or the former lawsuits, off the top of my head, I can't provide those case numbers to you, but I would be happy to provide them to the committee. They've been challenged in states across the nation.
In that 1981 case, I'm not familiar with it. Does it touch on the prurient interest or outside of just being a drag dancer or wearing costumes or makeup, whatever it may be? When you get into the prurient interest, does it touch on that in that case?
Well, I think in the proposed bill as well, this bill is seeking to go beyond that, because in the adult performance it says to a prurient interest or similar performer, something to that extent. So again, the intent behind this is to sort of blanket performance of drag in a variety of spaces, including other kinds of performance. This could touch upon Shakespeare in the park. This could touch upon Muni performances. So really, the vagueness of this bill would have devastating impacts, as well as being a direct target on a vulnerable community.
And I know you mentioned libraries. This bill is a threat to libraries. Can you elaborate on that?
Yeah, so when I'm looking at this bill, and again, we have sort of this broad container here for, I'm just going back up to page 1 here, where we have the definition of adult cabaret performance included here, or similar entertainers, whether or not the perform for consideration. And then on our last page here, where we have a person who commits the offense of engaging in an adult cabaret performance, if such a performance is on public property or in a location where the adult cabaret performance could be viewed by a person who is not an adult. So there are programs sometimes where drag performers will come and do storytelling at libraries. So with the vagueness and sort of totality of locations included in this bill, it would seem potentially that this bill would be targeting those types of programs and free speech in that context.
Any further questions for the witness? Seeing none. Before we move to the next witness, and you can just leave your witness form up there, we're going to move out of the subcommittee and back into the normal committee. Mr. Secretary, can you please call the roll?
Senators Schroer.
Here.
Gregory 15. Brown 26. Coleman. May. Roberts. Schnelting.
All right, since we have a quorum, I'm going to move that we go into executive session. Do I have a second? Second. Having a second, all those in favor signify by saying aye. Aye. All those opposed say nope. The ayes have it. We are in executive session. I now move that we bring Senate Bill 218 from Senator Black before the committee. Do I have a second? Second. I have a second. All those in favor signify by saying aye. Aye. All opposed say no. And the ayes have it. The bill is before the committee. I now move that we do pass Senate Bill 218. Do I have a second? Second. Having a second, any discussion? This is the bill on the treatment course from Senator Black that we heard last week. Hearing no discussion, Mr. Secretary, please call the roll.
Senators Schroer.
Aye.
Gregory 15.
Aye.
Brown 26.
Aye.
Coleman. May. Aye. Roberts. Aye. Schnelting.
By a vote of 5 ayes, 0 nays, you have voted do pass Senate Bill 218. I now move that we get out of executive session and go back to the public hearings. Do I have a second? Having a second, we will now return to the public testimony on Senator Brattin's Senate Bill 295. Next witness in opposition, please come forward. Make sure you have your witness form and begin when ready.
Hello, my name is Cammie Storm, and I'm here because SB25 is yet another attempt to legislate transgender people out of existence. But let me be clear, you cannot erase me and you cannot erase us. SB295 is unconstitutional. It violates the First Amendment, which protects freedom of speech and expression. Drag performances, gender expression, and artistic performances are all protected under the First Amendment. The government does not have a right to selectively censor performances simply because certain lawmakers disapprove of them. This bill also violates the Fourth Amendment, which protects against unreasonable government intrusion. SB295 opens the door for law enforcement to police people based on their appearance and expression, giving the government the excessive power to criminalize LGBTQIA+ performers without cause. Most importantly, this bill violates the 14th Amendment, which guarantees equal protections under the law. It unfairly targets transgender individuals and LGBTQIA+ performers, treating them differently under the law compared to other performers. The government cannot single out marginalized group for discriminatory treatment under the guise of protecting the public. SB 295 is not about protecting children, nor is it about public safety. It is about control. It is about using the power of the state to silence and erase transgender people and a broader LGBTQIA+ community. Missouri's own Constitution echoes these protections. Article 1, Section 8 of the Missouri Constitution defends freedom of speech and expression, reinforcing that censorship laws like SB 295 have no place in our state. Article 1, Section 2 guarantees that all Missourians are entitled to equal rights and opportunities. Yet this bill seeks to single out and punish a specific group of people. If you pass SB 295, you are telling transgender people, drag performers, and LGBTQIA+ Missourians that their existence is a crime, that their art and their expression and their lives are up for debate, and they are not. No law you pass can erase us. No attempt to criminalize our joy will make us disappear. You cannot legislate transgender people out of existence. We will continue to exist, to express ourselves, to live freely, because that is our constitutional right. Thank you, and I urge you to vote no on SB 295. Protect the Constitution, protect freedom, and protect fellow Missourians.
Thank you for your testimony. I know you had mentioned violations of certain amendments. Do you have any case law?
I do not have case law with me, but I can email you tonight, sir.
Thank you. Any questions for the witness? Seeing none. I'm going to move to the next witness in opposition. Please come forward, make sure you have your witness form, and proceed when ready.
Good morning. My name is Cara Carter. I am an educator, a theater educator, to be precise. I have had the great privilege of teaching theater and speech and debate in the Columbia Public School District for the last 2 years. It has greatly impacted my life, and the impact that it has had on my students is immeasurable. I am testifying on behalf of myself, both as an educator and as a performer, a member of the community theater community in Columbia, Missouri, against this bill. I apologize for using my phone for my notes. I am normally much more put together than this, and my students, if they saw this, would slap me on the wrist for this, but I have what I have. I oppose this bill on a variety of different reasons. First of all, as a theater scholar, someone who has a bachelor's degree in theater and a master's in social studies, I believe that theater is not only an art, it is part of the human existence. To limit the kind of stories that we can tell not only limits our worldview, it limits our students. It limits our young people. These things are going to be there. I am not suggesting that we expose minors to things that are sexual in nature, but drag is not sexual in nature. It is a right of expression. There is nothing sexual in nature. It is what we put into it. It is the meaning that we derive from it. I'm going to move on to my first reason, economy. Community theaters in Columbia alone generated an estimated revenue of $439,599 per year. That is Columbia theaters alone. That is tax revenue, where if this bill were to be passed, that will be severely limited for the state of Missouri and the city of Columbia. Several of these community theaters have no choice but to hire actors who do not identify as the correct, and I am putting air quotes, correct gender due to a lack of performers. The St. Louis Shakespeare Festival generated a revenue of $1.71 million in 2023 alone. Again, Shakespeare is something that we would lose access to. Several of Shakespeare's plays require cross-dressing. Limiting the kind of theater that theaters can perform takes away valuable revenue dollars from the state of Missouri and our cities and towns. Moving on to the restriction of freedom of speech and censorship. As of right now, our First Amendment guarantees us a right to freedom of speech and assembly to every citizen. In addition, this is an infringement of our 14th Amendment rights. Limiting what plays can be performed is a direct infringement of our First Amendment rights. There are plays such as Hairspray, Midsummer Night's Dream, Peter Pan, As You Like It, and several more that require and have cross-dressing and drag performance written directly into the script. Limiting these not only prohibits the playwright's freedom of speech, it also prohibits performers and theaters' freedom of speech. In addition, this bill limits who is allowed to be seen in public. It others American citizens simply to make a certain group of people comfortable. There are no legal cases where drag queens have assaulted or harmed minor children, according to the Harvard Law Review. None. To say that this bill is protecting children is misleading. The wording on the legislation is purposely vague. There is no definition, set in stone definition of the words adult cabaret. I do have a definition of the word go-go dancer from dictionary.com. An entertainer who performs popular dances on a stage or platform for the patrons of a discotheque or a nightclub, according to dictionary.com, is the definition of a go-go dancer. Sorry, moving back, my notes are all over the place. Again, my students would slap me on the wrist right now. If this bill is passed, we lose access to performing theatrical pieces and classics such as Shakespeare and Peter Pan. Moving on to my values as an educator and a performer. I am a board member of the Maplewood Barn Community Theater, and it has been my privilege to serve on that board and work on their play selection committee for the past 2 years. As a middle school theater teacher, we often don't have students who are the correct gender show up to audition, which means that we must cast students in roles that they might not identify as the correct gender. For example, I had the privilege of teaching Twelfth Night, which is another show that we would not be able to perform publicly due to the inherent plot. And I had to cast young girls in the roles of men because I did not have enough boys come out to audition for that show. Granted, we did a staged reading and the costuming was very vague on purpose, but I still had girls playing the roles of men in that show because I did not have enough boy students to audition. And this is a very common thing that you will see in middle schools. We often have more girls than boys show up to audition, but due to the dearth of material that is written that has more boy roles than girl roles, we have to cast who we have. If we limit ourselves based on that thing, then that, I'm sorry, am I out of time, Senator?
Yes, if you just wrap up.
Basically, as my concern as an educator and as an organization member, someone who has done community theater, is that we are limiting ourselves unnecessarily. Parents should have the option to decide what their children are exposed to. That is what freedom means in our country. Thank you.
So on that, I've got a couple questions for you. I
Yes.
pulled up a letter from Attorney General Andrew Bailey from 2003, and I know you said that parents should be able to direct their children and what they're exposed to. I think that there was an issue in Columbia, which I don't know if you're familiar with, in 2023, and I don't know if you're very well versed in this, but it was alleged that kids were sent to a drag show on a field trip without parental consent.
So I am aware of the issue. I was the fine arts secretary at Rockbridge High School during that incident. From my understanding of the incident, it was a diversity breakfast, not an inherent drag show. There were drag performers present at the breakfast, but it was not entirely a drag show.
In looking at some of these definitions, I know you had mentioned adult cabaret. Adult cabaret is mentioned in 573-509. There's age limits on exposure to certain performances, 573-507. When it comes to drag and drag shows, and I know you mentioned theater a lot, I was in theater, and I think that we need to carefully define what we believe is drag that has the prurient interest and what doesn't. What is theater? What is something that you can see on Frozen, as one of the people were mentioning earlier. And I think some of these, yes, you will have kissing scenes or something like that. And I think quite clearly in our definitions that wouldn't rise to a prurient interest and overexposure to sexual material. So do you have any guidance as an educator to kind of tighten up some of these definitions to make sure that we're protecting kids, protecting parents and what they're allowed to expose their children to, but also at the same time tighten down and prohibit some of these performances that may expose kids to adult material?
So me personally, as someone who has directed community theater, I always include content warnings for things that may be considered a little bit more risque. For example, when we did a play called Trap last year, again, I had to cast girls in the roles of boys, and Trap had warnings of there is violence depicted, there are strobe lights. Adding content warnings is a much cleaner way of doing this than straight up banning it entirely. Does that answer your question?
Well, it's still very gray for me.
Okay.
And that's, I think, as lawmakers, that's something that we're going to have to do, is tighten down on some of these definitions to not ban Shakespeare, but at the same time, if it's a rendition of striptease, Demi Moore or something that kids shouldn't be exposed to. So I do think there should be some content warnings. I do think that there should be, similar to our law, some prohibitions on what kids can be exposed to. And I know, speaking with the sponsor on this, that's his goal, is not banning theater. So I'll open it up to any questions that we have. Senator May.
Yes. I just want to tell you, as a fellow theater student, I played viola in 12th Night. So I agree, and I love Shakespeare in the Park. So we definitely have to, have a fine line as to what we're trying to do here, because those are just phenomenal art that you do not want to eliminate.
Thank you.
Senator May, you were in theater?
Yes, I was. At Vassar Powerhouse Theater, New York Stage and Film.
Maybe you and I can be in a play together.
We should.
We should.
I did a lot of performances in Central Park.
All right, we'll talk offline. Senator Gregory, did you partake in theater?
I did not. My
Okay.
apologies. I'd love to see a video of your performances.
Oh, absolutely.
All right.
Any further questions? Seeing none. Thank you for your time today. Next witness in opposition, please come forward. And again, reminder, you'll have 5 minutes, and as we get closer to the end of our time limit, we may have to shorten that to 2 or 3 minutes. So proceed when ready.
All right. Good morning, Senators. My name is Brandon Banks, a Boone County business owner, and I'm here to oppose SB295, a bill that threatens freedom of speech and artistic expression while damaging Missouri's economy, especially in tourism, entertainment, and the gig economy. I grew up in Troy, Missouri, and started my first business there, a children's theater production company. Under SB295's vague language, my theater work could have been labeled sexually oriented business, just as it involved any play, motion picture, film, dance, or exposition performed in front of an audience. As we've been talking about, there are many cases where theater in general, high school, middle school, you name it, could be at risk if the location of this production is anywhere that could be seen by the public. What about ballet? Haunted houses. I also worked in a haunted house as a makeup artist, creating monsters and characters. But SB295 defines an adult cabaret performance as including male or female impersonators performing outside of a club. So what happens when an actor in costume doesn't fit traditional gender expressions or expectations? Is Frankenstein illegal now? What do we define as the Jeeper Creepers gender? Missouri is just recovering from an economic devastation of COVID-19. 1 in 14 Missourians depends on tourism and entertainment, and we finally rebuilt events that bring people to our state. Instead of celebrating that, SB295 threatens to shut down the very shows and performances that drive tourism dollars. In college, I saw my first drag show, a show that's now been running over 10 years and won national awards, and I believe in your district, actually, of Warrensburg. I've also performed with Dancing with the Missouri Stars, helping raise thousands of dollars for charity. But SB295 vague language on topless dancers could mean ballet performances. Could mean ballet performers shirtless in a family-friendly show. Are they now considered prurient? Who decides what is obscene? Even movies are included in this bill. Does that mean parents who show their kids Mrs. Doubtfire, a film about a father dressing as a woman to be with his kids, could that be criminalized? Could that become a felony if other people are included in someone's house or in public if they're showing that movie? Senators, Missouri has real issues to tackle: veteran health care, homelessness, economic growth, and instead SB295 is manufacturing a problem where none exists. As it's been said earlier today, there are plenty of ways that groups in this state, for example, are utilizing their own parameters to make sure that family-friendly content exists and is censored in the right way for that audience. We don't need censorship. Artistic expression is already managed by these venues and age restrictions. We need progress, and I urge you to oppose SB 295. Let entertainment and tourism thrive in Missouri. Thank you for your time. I will take any questions you have.
Thank you for making the trek out here today with the snow and everybody else that's here as well. Question that I have for you, I know you mentioned Mrs. Doubtfire. Where do you think Mrs. Doubtfire would fit within this definition on adult cabaret performance?
Well, I think that if a person, a venue, an organization were showing that movie in the park, for instance, Mrs. Doubtfire would be a film where there is a male entertainer that is impersonating a different gender, and that then could be considered showing that content in a public place.
But where in Mrs. Doubtfire, I've seen that movie countless times, where is the prurient interest, that's the qualifier for male or female impersonators who provide entertainment that appeals to a prurient interest or similar entertainers? Again, that qualifier is appealing to prurient interest.
Yeah, I think that prurient interest is for many different people to assume and understand what their
But how do
version
you
of that
feel
is.
on Mrs. Doubtfire? Where do you think that prurient interest is in Mrs. Doubtfire?
I think that there are many things inside of this bill that could be used against Mrs. Doubtfire, and I think that prurient interest is a
Well,
big
my
term
my question to you is on Mrs. Doubtfire. Where do you believe in the movie, and it's probably an hour and a half long, where is that qualifier of male impersonator or female impersonator?
I would say that there are times that Robin Williams is changing from character to character, and you see, mesh body, you see, all kinds of things that might be considered topless or, of other interest that people, again,
But you
I don't
believe that's
consider it.
prurient interest?
I don't believe so, but I think that there are many people, this bill allows people to
Do you believe a reasonable
determine.
prosecutor would believe that Mrs. Doubtfire appeals to the prurient interest?
But I also don't think this bill says a reasonable prosecutor. I think it says that any person that's walking outside of a facility could then deem their understanding of this bill. So I think this bill has very wide-ranging, far-reaching, broad definitions that don't give a platform for exactly what we're trying to discuss here.
Well, if anyone believes that Robin Williams' very hairy arms and makeup appeal to the prurient interest, I will be glad to work with you to tighten up this definition. Any questions on or for this witness? Do you have a question? No. Okay, seeing none. Thank you for your time today. Next
Thank
witness
you.
in opposition. And we're going to have to move to 3 minutes as we have another bill after this as well.
I'll go as quickly as possible then. Hi, my name is Stevie Miller. I'm from West Plains. I'm a hugely concerned non-binary trans man, Missourian, and occasionally a drag performer. I oppose this bill. Drag bans like SB 295 aim to eradicate people like me, both as a drag performer and a trans person. A little about me. I have a bachelor's degree in music education. I was a teacher for a while, and I performed extensively through my many years as a singer and actor. I was in the closet, and I could not admit to myself that I was trans until I was 30 years old. I started transitioning 5 years ago, finally getting hormone replacement therapy 2 years ago. And I just want to say there are those that see my existence inherently as a trans person or a drag performer as inherently sexual. Where are we drawing the lines on the male and female impersonators here? With other bills defining sex as biological, make no mistake, we see the bigger picture here. I wear clothes across the gender spectrum in all capacities, and I sing everywhere I go. Is that considered adult cabaret? Or only if I'm out at night with children nearby? Which, side note, wild that we are using that term, cabaret, it is just a nighttime entertainment, but considering the show Cabaret is about a descent into fascism and this systematic attempt at removing trans and gender nonconforming folks from the public eye looks a lot like fascism. I said I also helped build the first LGBTQIA plus Pride event in my hometown of West Plains with Cammie Storm back there. I graduated high school in this town, and my experiences in this town shoved me into that aforementioned closet. Nothing like this was imaginable around these parts, and it's something younger me needed to see, to know that it's okay to be myself, to love how I love and be who I am. For our family-friendly Pride in a local park, we brought in drag story time, professional drag show, and I even hosted amateur competition. Pride was so well received, over 900 attendees at a first rural Pride event is unheard of. But that's how we roll in West Plains. The local law enforcement was present, and it was stated for the record at a city council meeting where a similar drag ban was introduced that neither our performances or attendees have violated any of our existing city ordinances, and they felt no further laws were required. However, our drag queens did have outfits that match definitions in this bill. I quite live my hometown. I'm a hugely proud Missourian. I've traveled across the country, and I still found myself coming back here. This bill seeks to stop almost everything I love and hold dear around here. In West Plains, our thriving community theater programs often don't have enough men and women step up to fill those roles. I performed in a production of It's a Wonderful Life last December at the historic Avenue Theater, and many roles were performed as cross-dressed. There was plenty of suggestive language. The show was late at night, and there were children in the show and in the audience, because this is a beloved Christmas time classic.
If we could just wrap up, your time is expired.
There's definitions here, put that as adult cabaret. Y'all got better stuff to do than continually marginalize my group of trans people and LGBTQ.
Well,
thank you for your time.
Thank you for your time. And I just want to direct everybody on to 573.010. A lot of these definitions carry over to define what I believe the sponsor is trying to get at. And adult cabaret is the first one that's defined. Nightclub, bar, juice bar, restaurant, bottle club, or other commercial establishment, regardless of whether alcohol beverages are served, which regularly features persons who appear semi-nude. And I went back, these definitions date back to 1970s, is when the legislature put a lot of this, there's pornographic material, explicit material. So again, as you're communicating with this committee to try and tighten up some of these definitions, keep that in mind, that a lot of these terms are carryover from the 1970s and definitions that we have in 573.010. Any questions? Seeing none. Thank you for your time.
Thank you.
Next witness in opposition, please come forward. Make sure you fill out a witness form, and you will have 3 minutes when you are ready.
Yes. Hello. My name is Kate Giant. I am a trans musician from St. Louis. This bill really terrifies me. You say that the meaning of the terms in this bill are clear, and that's great for you. That's great once I get to court. You'll be hard-pressed to find someone in St. Louis that can pronounce prurient, if you're familiar with our accent, let alone know what it means, and that's an issue. The health and safety for trans individuals is at risk the second we're in police custody. It's great that we may be safe once we get to court, but if we have to go through being in the wrong gender prison, having our medicine taken away from us, etc., just interacting with police is inherently dangerous for us. So I'm really terrified if I'm out playing a show and I feel I'm safe. I wear more clothes than most female DJs that I might be playing with. But if someone has the wrong opinion of what I'm doing, I have to deal with an interaction with police. And that scares the crap out of me. Like, that's not safe in St. Louis. We had an officer swerve to miss an invisible dog and crash into a gay bar and then harm and arrest the owner. If I'm in that environment, any interaction with law enforcement is bad for me. And this law is teeing me up to have to deal with them more potentially. I do play all ages open mics. If someone happened to be walking by and wanted to cause trouble, they could. And just my situation could go very negatively just because of who I am. At its base, this risks further wrongful police interaction and potential short-term incarceration for trans people. With a fair amount of ignorance, that can lead to convictions, and taken the wrong way, this is the first step towards a very bad path where we're just picked off the street for being who we are. Stonewall has been in the news a lot lately. This bill for the trans community could be one more step going back to the conditions that caused that situation. That situation came about because police were able to interfere, harass, and harm trans people just for being who they are. And this is one more step going back that way. Thank you.
Thank you for your testimony. Any questions? Seeing none. Move to the next in opposition. Please come forward. You'll have 3 minutes. Make sure you have a witness form that you leave at the witness stand.
Good morning, Senators. I'm Austin Kimes, and I am an educator at the University of Missouri and work for the Columbia Farmers Market, and I'm here to testify against Senate Bill 295 because of its vague language and failure to establish key definitions of phrases. In the 1980s, legislation that you've previously mentioned was used to target trans and non-binary individuals for existing within public spaces. The legislation's vague language can easily be used against other minority populations who choose clothing as a means of self-expression within public spaces. But I'm not here to talk about the queer, non-binary trans experience within this legislation. I'm here to appeal to the predominantly heterosexual population of this committee. The legislation's vague language can be used to target anyone, including heterosexual people wearing fashionable or non-standard clothing. That could include college students attending theme parties like Greek and anything but clothes parties, or even just existing in the summer in a mesh top or a crop top or a skirt. So this bill's vague language creates an argument that also clothing is not inherently political or artistic. In lines 90 through 92, the legislation claims that a reasonable person would say the material lacks artistic or political value. Quite frankly, that's incorrect. Look at the amazing performers across our state, not just in drag, but in music, in like fashion and everything else. And I say, come to those performances and say that is not art, that is not political. This legislation's vague language does not define who a reasonable person is, and it uses the term contemporary community standard, which is never defined throughout the legislation. Community standards are situationally dependent. For example, if I were to walk into a bank, I would be expected to be wearing a khakis and a button-down, if not a full suit, similar to y'all in the committee. But if I showed up wearing what I'm wearing today, is that not a violation of the contemporary community standard that is stated in this law? Because the general population of the people I'm presenting to are wearing this. So the attendees, and as it associates with adult entertainers targeted within this legislation, everyone at the venue could say this is a standard of decency that we appreciate and say meets the contemporary community standard. But Joe Schmo could see from the window, call the police and say, I disagree with this, and use his personal beliefs against the general population where the entire venue and audience were in agreement and support of the entertainment. Most importantly, though, the last lines in 250, 520, 15 through 17 on page 9 are in direct violation of the First Amendment by means of, quote, preemptively restricting expression and discussion of politics that are against the vague, undefined terms of contemporary community standards. The use of this legislation clearly sets out to censor and restrict any discussion against the status quo and criminalize use of clothing in political discourse and individual representation. The passing of this legislation without addressing the First Amendment violation and the undefined terms of contemporary community standards and who a reasonable person is will have a terrible impact on our state's art and entertainment venues beyond just adult spaces. So as predominantly a right-leaning state representative committee, I'm asking you, for the sake of state and individual autonomy, to not support this bill. Thank you.
Thank you for your testimony. Any questions? Seeing none. Next witness in opposition, please come forward. You'll have 3 minutes. Make sure you have your witness form and proceed when ready.
Hi, my name is Carl Basinger. I'm from Columbia, Missouri. I'm a concerned parent and citizen testifying about Bill 295. This bill is unnecessary, as Missouri already prohibits exposing minors to shows deemed sexually explicit or harmful. As a father of 3 daughters, I recall attending events, pride events, theater productions, and etc. Unfortunately, with those events, I encountered more individual postings as Christians who are shouting hateful and judgmental words to people they don't even know. Honestly, that terrified my children. As I explained to my children, those yelling do not represent God, who loves everyone for who they are. In closing, I just want to empathize. As Americans, we all have the freedom of speech and expression. We need to stop dividing people with bills like this. And please, lawmakers, vote against Bill SB 295. Thank you for the committee, and thank you for your time.
Thank you for your testimony. Are there any questions? Seeing none. Next witness in opposition.
Hello, my name is Ryan Carter, and I'm representing myself. I am speaking in opposition to Senate Bill 295. I'm here to provide the perspective of a community actor. I've been acting and volunteering with the Maplewood Barn Community Theater in Columbia since 2021. I'm here because this bill, if passed, will prohibit adult cabaret performances where a minor is present. The specific definition of what that is, as stipulated in the bill, includes, among other things, male or female impersonators who provide entertainment that appeals to a prurient interest or similar entertainers, regardless of whether performed for consideration. That last bit is what I'm focusing on. I'm obviously not a lawmaker, but if I'm reading this right, based on the definition of what an adult cabaret performance is, as stipulated in this bill, you would be prohibiting cross-dressing in almost all theatrical performances. This means that no professional, community, or school theater in Missouri would be able to put on plays like Peter Pan, Hairspray, Twelfth Night, As You Like It, or Mrs. Doubtfire, without specifically prohibiting children from attending. And if children aren't allowed to go to Peter Pan or Mrs. Doubtfire, nobody's going to put on those shows. And taking this a step further, this means that no theater will be able to have a male-presenting person act in a female role, or vice versa. And the fact of the matter is that in community theater and in school plays, cross-dressing is a necessity. Historically, back in Shakespeare's time, women weren't even allowed to perform. Every female role had to be performed by men. They had to cross-dress if women were to be portrayed. In the modern day, there are far more women that perform than men, at least in mid-Missouri. It is not uncommon for women and girls to perform in male roles if the show is going to happen at all. I was talking to my wife about this, a theater teacher, who just testified. She's a teacher at a public middle school. She teaches the history of theater. She teaches her students about ancient Greek, Roman, Egyptian theater, Shakespearean theater. You can find examples of cross-dressing in plays from all of these sources. She's going to be putting on a comedic play this semester called I Hate Shakespeare. In it, the script specifically calls for the same actor to play both a female and male role, Ophelia and Laertes. This is not offensive. It's incredibly common. Speaking personally, the very first show I ever performed in at the Maplewood Barn, a play called 5th of July, was very nearly an all-female cast, if not for the fact that I and a couple other men decided to audition at the last minute. The leading male role was played by a woman. One of the men who performed is a trans man. One of the shows I was in last year had a non-binary actor performing as a man despite being assigned female at birth. If this bill passes as written, they wouldn't be able to perform as men, if for no other reason than they would be afraid to do so. The thought of that is infuriating to me. If you identify as a specific gender, you are that gender and should be able to express yourself to fit that gender if you want to. If you don't identify as any gender, you should be free to perform in whatever role you want. This bill only serves to make queer people scary.
Your time has expired. If you could just wrap up.
I have nothing more to add than what other people have already said. That's
and if you have anything other that's written, feel free to send to our office, and we'll get to all the committee members. Briefly, I know I'm going to ask the same question. Similar to Mrs. Doubtfire, you mentioned Peter Pan. Very well aware of the movie or the plays. Where is the prurient interest in Peter Pan? And I do understand the issues with the definitions, but where would you believe a reasonable person would find a prurient interest with Peter Pan?
No, I don't. The specific thing I'm needling on is, or similar entertainers regardless of whether performed for consideration.
But
that is incredibly
that similar entertainer language is relating back to the men and women, male or female impersonators who provide entertainment that appeals to a prurient interest, or similar entertainers. So that prurient interest is that qualifier. And I believe we could tighten it up. I think we're going to tighten it up if this bill moves forward. But do you believe that there's any prurient interest with Peter Pan?
If we're following that definition by what an average person would consider reasonable, which I question that definition, then no, I think it would be fine.
Well, I greatly appreciate your insight and testimony today. Are there any questions? Seeing none, thank you for your time. Next witness in opposition, please come forward. You'll have 3 minutes. Make sure you have your witness form dropped off and proceed when you are ready.
Hello. My name is Devin Christensen. I'm a representative of Parents for Parents, a community of parents of LGBTQIA+ people. There are many issues today with which parents must deal that the Missouri Senate could address: affordable child care, early childhood education, school safety, bullying prevention. The list goes on. Instead, we are here discussing adult cabaret performances, also known as drag performances. Most drag shows don't even allow patrons under 21, and even fewer allow patrons under 18. Those that do are specific to drag story hour or family-friendly drag shows. Just as parents have a right to decide what movies they believe are appropriate for their children to watch, they should also have the right to choose to take their children to drag performances. Both drag shows and movies offer forms of entertainment and education, and parents are in the best position to judge what content aligns with their family's values and interests. In a free society, we trust parents to make informed decisions about the experiences they provide for their children, whether it be family-friendly drag shows that promote acceptance, or a movie that offers entertainment and life lessons. Restricting access to one form of artistic expression while allowing another undermines the principles of parental choice and freedom. Ultimately, it is essential to respect and uphold the rights of parents to choose the cultural and educational experiences that they believe will best benefit their children. In doing so, we ensure a more open society where different forms of expression and entertainment can thrive. Also, drag performances are a form of artistic expression protected under the First Amendment. Banning them infringes on free speech and artistic freedom.
Thank you for your testimony. Got a question on the extent of parental consent and parental rights. Do you believe that there is a stopgap measure that parents should have the ability to take their kids to a strip club?
I don't, but the strip club has the responsibility of not allowing people under that age.
But for parental consent purposes, if they want to put in an X-rated pornographic film at home while their kids are sitting there.
Not my business.
But do you believe that that's appropriate? Do you believe that they should have the right to expose their kids to that X-rated material?
It's not my business.
Do you believe that parents should have the right to allow their kids to smoke marijuana at 12 years old?
What does this have to do with?
I'm trying to figure out for
me,
you,
I
what do you believe?
As a parent, that I should have the right to bring my child, and I have my grandchild, to a family-friendly drag show for entertainment.
So the extent of parental consent, in your mind, parents should have the ability to expose their kids or allow their kids to do whatever the parents believe is in the best interest of that kid, regardless if it's X-rated, drugs, or alcohol.
No, that's not what I said.
Well, that's what I'm asking for clarification.
I am saying that I think that the parents should be able to, just as they can choose a movie for their children, should be able to choose a family-friendly drag show. Movies say parental guidance, and for a family-friendly drag show.
What would you believe is family-friendly? What would make it not family-friendly?
What would make it not family-friendly?
Correct.
I don't know that I've been to one that wasn't, but I would assume sexually explicit or something to that effect. I've only been to those that were family-friendly.
Thank you. Any further questions? Seeing none. Next witness in opposition.
Hello, I am Kai Brunkhorst. I'm a 20-year-old trans man who is concerned about this bill passing. Participating in drag as a performer gives the performer a sense of community and a creative outlet. Having access to both of these things can overall improve your mental health, leading to reduced rates of anxiety, depression, suicide attempts, and suicidal ideation if the person is dealing with those things. In regards of having a creative outlook / creativity is among one of the top characteristics employers are looking for when deciding to hire someone or not. How, if I were to hire you, how would you implement your creativity to get out of a difficult situation? How would you look outside of a box, the preferable box, to solve a problem? As a drag performer, you learn how to flex your creativity through expressing yourself through your drag looks, learning how to have critical thinking skills issues, solving problems, and gaining the ability to adapt to sudden change, like learning how to time and schedule yourself. As a drag artist, individual sense of their own self-expressions improves over time, as well as confidence in their personal empowerment. Being able to recognize where you are at with these certain aspects of yourself at any age is critical. SB295, if you would pass this, would restrict an art form that would provide a safe space for people to develop these aspects of themselves and learn more about themselves. Another beneficial aspect of drag is it can be used to raise money for charities. An example, in 2023 in Auburn, Alabama, there was a 5th annual drag bunch that was hosted, family friendly, where the kings and queens that performed raised around $50,000 for Glasgow Children's Hospital, and that money was used to buy food and gas and toiletries for the people dealing with their kids at the hospital. For the fact that drag can be used to raise money for charities, provide a sense of community, provide an art form where people can express themselves and raise their confidence, please vote in opposition of HB 295. Thank you.
Thank you. Any questions for the witness? Seeing none. Next witness in opposition, please come forward.
My name is Rebecca Maddox. I am from Jefferson County, Missouri. My thoughts are disorganized. I apologize. I have a 5-year-old daughter at home. I'm sorry, I'm jumping all around in my brain. Anyway, I have attended a couple of all-ages drag shows, and I personally believe that the content I have seen there is like more tame than stuff that my daughter has been exposed to, say, at the grocery store, just based on like what other adults are just grocery shopping doing. Like, more often than not, I would have to avert her eyes, like, at that sort of situation, whereas at the all-ages drag shows I've been to, I feel comfortable with the content happening there. So I feel as if this proposed bill unfairly kind of targets members of the trans community and the performers of the drag community. Echoing what my fellow St. Louis friend said, I feel like extra attention on the transgender community is dangerous for some individuals, just based on some of the crimes that we have witnessed in the St. Louis community. I'm just kind of going on a tangent right now, so I think this is all I have to say, but I echo everything everybody has said.
Well, thank you for your testimony. Again, if there's any further thoughts that you have, feel free to email them to us and we'll share with the committee. Any questions? Seeing none. Next witness in opposition. It's the loudest witness in opposition.
Hi, Sharon Galway Jones here today on behalf of Promo to express opposition to the bill. I'm not going to go into everything, but I do want to answer your question. Our concern is that or similar entertainers is a separate and distinct category that is not modified by prurient interest. So if you look at that, that would include entertainers similar to go-go dancers, which we all admit could be, a Hooters waitress, a cheerleader, anything. So that's our primary concern, is that it's not that prurient interest is vague, although I think it could be used to target drag shows in their essence. It's that other similar entertainers broadens it to anyone who's a male or female impersonator.
Senator May.
So do you think that it will, if you had a person who was in the middle of the street and decided to sing or dance in the middle of the street, going down the street, and they were dressed cross, that could potentially be a violation under this legislation?
I think that they could be targeted if they did it on the wrong street, yes. And I think the other good example was the musician who came up earlier, who is a trans woman just living her life. If she goes and does her work, that could be considered a adult cabaret performance under this definition. But as always, I'm happy to talk with you more later.
Well, and it seems like the more that you talk, it's getting better. Your throat's
It is getting better. I've had so many cough drops.
So we're going to move to a 1-minute time limit for any remaining witnesses, as we have a strict time limit to get out of here. Are there any further witnesses in opposition? Make sure you fill out a witness form. You can leave that at the witness stand either before, during, or after your testimony. And again, you will have 1 minute for wrapping up the testimony. Again, Senate Bill 295.
All right, give me just a second to get it all pulled up here. I'm a chaotic thinker, so I had to put it all in my notes. But good morning, everyone. It's sad that we're here today fighting this, but I'm glad that we're here together. I want to start by telling you about a book filled with stories of violence, war, and genocide. A book where women are treated as property, where rape and incest are common, where the entire cities are burned to the ground, where people are slaughtered simply for being different. A book that, despite its impact or its explicit content, is not only available to children, but placed in hotel rooms, defended in courtrooms, and even fought for to be put into schools. I'm, of course, talking about the Bible. That might come as a shock to a few of you, but yet here we are, debating whether a child should be allowed to see a drag performer, read them a story, entertain a crowd, or simply exist in public. Here we are, pretending that drag is inherently inappropriate, while the very book so many of you claim as your moral foundation is filled with things more explicit than anything I have ever seen at a family-friendly drag show. If this were truly about protecting children, we would be here talking about real threats like gun violence in schools, child abuse, poverty, the failing foster care system, but instead we're here debating whether or not a drag artist or a trans person in a sparkly gown is somehow more dangerous than all of that. Drag is an art form. Was that my time?
That is your time. You got a couple
right,
seconds to
that's
wrap
okay.
up, and you can feel free to email that to us, and we'll get to all the committee members.
All right, well, I will definitely get it emailed to you.
And what is
I'll
your
make
name for the record?
My name is Pharmaceutical. But I will make sure I get this all in, and I'll make sure you all get a copy of
I
my
appreciate that.
testimony.
Any questions for the witness? Seeing none. Any further witnesses in opposition of Senate Bill 295? Make sure you have a witness form filled out. You'll have 1 minute.
Okay, I'll try to just summarize here. Cole Faubert, St. Peter's. Here's the thing. The assumption that drag or being trans is inherently sexual is the core of all this. All the bills being passed, Iowa, recently, this year, Iowa, is trying to pass anti-trans bills. The assumption that being drag or trans is inherently sexual is based around the notion that men wearing makeup and dresses is sexual. Let me ask you a question. Why is wearing a dress and makeup considered sexual when men do it? Why is it considered sexual when women do? And it is. Anyone who grew up as a girl getting catcalled growing up knows that women are considered sexual objects. Girls are considered sexual objects. Why then are you okay with us being portrayed as sexual objects to children, but not men being portrayed that way? That doesn't sound like protecting children to me. It sounds like grooming them, preparing them to become women who are sexual objects, but men aren't allowed to be that way. You can't say this is natural, that women being sexual is natural, us wearing makeup and dresses is natural, because women are born with the same plain skin as men. No makeup, no dresses when we're born.
Your time has expired. You have a couple seconds to wrap up.
In nature, the men are the flashy ones, peacocks, lions. If you want to talk about nature and natural stuff, men being flashy is natural. That makes drag natural, not sexual.
Thank you for your testimony again. If you have any additional thoughts, submit them, and we will get to the committee. Any questions? Seeing none. Any witnesses in opposition? Seeing none. Any for informational purposes only? Seeing none. A couple of comments from the senator.
Yes. I just wanted to edify for the committee that this does not infringe on First Amendment right and people's capability to express themselves. This is ensuring that it's content that is appropriate for children. That is what it is. The foundation of this bill is protecting children and making sure they aren't exposed to inappropriate content. But unfortunately, as we've heard in testimony, we see that there's a trend of wanting to target children and put them in the crosshairs in this sort of content. And it's incumbent upon us to ensure that we're protecting children. This does not stop people's capability from expressing themselves. It's where you're expressing yourselves and how you are expressing yourselves, in which we're saying this is inappropriate behavior, and we do not tolerate this as a state. Just like we don't tolerate kids to go into strip clubs, we shouldn't tolerate that regardless of sexual inclination. So I just want to emphasize that it's occurred, and we just heard numerous testimonies that it is occurring, and children are the targets. And it's incumbent upon us that we have to protect kids. Thank you.
Thank you, Senator. This concludes the public hearing on Senate Bill 295. We will now move to Senate Bill 318, sponsored by yours truly, and I'm going to pass the gavel to Senator Brown.
So you didn't want me to chair the committee? I mean, I'm offended. What do you think I'm gonna do?
Senator May, you know I love you. Thank you. I'm going to be very brief, as I know we have to get out of here in the next 20 minutes. For the record, Senator Schroer on Senate Bill 318, organized retail theft. Before you've got the bill as filed. I've got my own. I haven't gotten it drafted from our drafters, as I know they've been swamped over the past couple days. But I do have the language that we pulled from Senate Bill 52 and 44. We discussed this criminal provision on 570-030 on organized retail theft. I believe with at least two of the members and Senator Moon on the floor extensively. What you're going to see before you is an attempt to deal with what the Missouri Retailers Association has cited as $1.6 billion in losses over the past several years. Quite recently, SLMPD in the St. Louis region has arrested two men that stole $2.6 million plus throughout the metro area. So what this is going to do is clarify, like many other states have done, clarify the laws on organized retail theft with criminal provisions depending upon the level of crime and the amounts of crime throughout the region. It also allows for these prosecutors to utilize the Attorney General when necessary to go in multi-jurisdictions and prosecute. So with that, I'd be more than happy to answer any questions, and I know we have a couple witnesses here as well.
Thank you for that presentation. Do we have any questions for the Senator? Seeing none, first up that would like to testify in favor, please come forward.
Thank you, Senator.
Thank you.
Good morning, Mr. Chairman, members of the committee. My name is David Overfelt. I am the president of the Missouri Retailers Association. I'm also appearing on behalf of Associated Industries of Missouri, the Missouri Grocers Association, and the Missouri Tire Dealers Association. Organized retail theft has just grown and grown every year. I submit a letter from Schnucks. They're seeing it happening and grow every single year and compounding. You're also seeing a lot of gift card fraud happening. It's just getting worse every year. One other stat that I've come across is that, that's a couple years dated, so I'm sure it's much higher. Theft, sales tax, we've lost $141 million, probably more than that, in sales tax that could have been generated from all the products stolen or false refunds at retail. And I think that that's a pretty good sized number. We have had successful prosecution federally in Kansas City where a pawn shop operator was the boss, who was hiring people to go out and steal from retailers and bring it in. He had sold over $744,000 worth of stolen merchandise. Just through that. But this is done more than just not through eBay or the internet. They also will wholesale to smaller retailers and maybe markets, all kinds of different places. We see Monster Energy drinks disappearing from our store shelves and showing up at other store shelves. So they're pretty organized. They know what they're doing. This bill goes after that, allows aggregation, and allows the possibility, if the prosecutors in the counties that impacted have too much on their plate, to allow the AG to step in by their invitation only. The substitute.
Thank you for that testimony. Are there any questions for the witness?
Thank you.
Seeing none, thank you. Be sure to leave a witness form. Next up, they would like to testify in favor. Can I see a show of hands real quick? How many people are here to testify in favor? How many in opposition? Okay, we're going to, just to make sure we have time for any questions that might come up, we're going to limit testimony to 3 minutes.
Thank you, Mr. Chairman. My name is Jeff Brooks, registered lobbyist for Walmart, Inc. Just want to go on record, without being repetitive, go on record in support of the bill, and want to thank the sponsor for his work on not only on this bill, but the new language as well.
Thank you very much. Any questions for the witness? Seeing none, thank you for your testimony. Next up in favor, please come forward.
Good morning, Chairman, members of the committee. Doug Nelson, Clarkston Nelson, on behalf of the U.S. Chamber of Commerce. Appreciate the sponsor for bringing the bill. We see this prolific across the country. It is organized, it is calculated, and it is impactful. So appreciate that. Happy to answer any questions in support of the bill.
Do we have any questions for the witness? Seeing none, thank you for your testimony. Next up in favor.
Good morning. Ward Cook on behalf of the Missouri Prosecutors Association. We want to go on record in support of this bill. We've been working on the language with retailers and Walmart, and we've tightened up the language, and we're very happy with it. Look forward to moving it forward.
Thank you for the testimony. Any questions for the witness?
Thank you.
Seeing none, thank you very much.
Thank you,
Be sure to
sir.
leave a witness form. Next up in favor.
Good morning, Mr. Chairman. Good morning, members of the committee. My name is Cade Tremaine. I'm here today on behalf of the Missouri Chamber of Commerce and Industry to testify in support of Senate Bill 318. Overall, organized retail theft is leaving Missouri businesses and business owners in unexpected financial hardship as they struggle to ensure that their products and their services aren't being lost to theft. This is ultimately deterring Missouri businesses from growing roots in Missouri and new businesses from coming to Missouri. So the Missouri Chamber supports this for two main reasons. The first being that it simply holds criminals accountable for organized retail theft, and the second being that it will attract businesses to Missouri with the confidence that they will not be facing significant financial losses that could potentially never be regained. So with that, I'm happy to take questions.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Next up in favor. Seeing none, any here to testify in opposition? Anyone here to testify for informational purposes only?
Lisa Panett with Armorvine, and we support the underlying legislation, but we have a concern. If you look at the definition of the offense of trespass, on the very first line, under 3, it says creating the danger of serious physical injury to persons. That's perfect. Then it says, or threatening or adversely affecting the health or physical well-being of any individual located in or around such retail establishment or similar public place. And we have a concern because this is the exact language that was weaponized against people, and we see that as also another place that could happen again if you weren't masking, if you didn't want to have a vaccination. That would fall under this category of adversely affecting the health or the physical well-being of an individual in that public place. That's all.
Thank you. Are there any questions for the witness? Seeing none, thank you for your testimony. Anyone else for informational purposes? Seeing none, this concludes the hearing for Senate Bill 318. With no further business coming before the committee, I would like to make a motion to adjourn. We are adjourned. All right.
All right. You know you shouldn't have been switching that turn.